Africa. Let's now take you to the latest from The Hague at the International Criminal Court, where in the last 1 hour or so, the International Criminal Court Appeals Chamber has ruled to strike out the use of recanted evidence in the case against Deputy President William Ruto and former radio journalist Joshua Arap Sang. In reversing that decision, on the use of recanted evidence, the ICC Appeals Chamber ruled that the trial court erred as the evidence was detrimental to the accused, a ruling that will definitely change the complexion of that case against Ruto and Sang. In studio to just put some more analysis and on that ruling is lawyer Martin Oloo. Martin, welcome to Bottomline East Africa.
Thank you, Ben.
Is this ruling marking the end of the collapse of the prosecution's case against Ruto and Sang?
I can't say that it marks the collapse, but it marks a major milestone for the accused persons, because definitely the lower court had said, look, prosecution, whatever you have, throw it in there. But the Court of Appeal is saying no. And basically there are two issues that the Court of Appeal is saying. One, if you're going to use Rule 68 on pre-recorded evidence, it needs to be with the agreement, both with the defense and the prosecution, and particularly it needs to be subjected to cross-examination.
Right.
Now, in this particular case, it's impossible to subject to any scrutiny, any recanted evidence, because the witnesses are not available for cross-examination. It makes the case prejudicial, as the Court of Appeal has rightly observed.
How big is this for the case, for Ruto and Sang specifically?
No, for them it's fantastic. I mean, it's great, because definitely they are going to have to deal with less witnesses or less material in their defense. So this is good news for them. Of course, for the prosecution, if they were seeking to fill up a gap in their evidence, this is a loss for them. This is bad news for them.
What will Bensouda be missing in terms of evidence?
You see, what Bensouda may have been anticipating is, look, I may not be having very strong live witnesses here, and therefore on cross-examination, these guys can be knocked off. So let me throw in a bit of this recanted evidence and see whether by allowing this evidence, the court can give me a lifeline. So it's possible that there was a lifeline in this recanted evidence. Now, with that lifeline gone, she must struggle to mine whatever value she has in the little evidence she has in order for her to prosecute this case.
Right. Obviously now the focus shifts to the no case to answer motion. And does this ruling have an impact on that motion?
Not exactly. And this is the issue that was being tested earlier. That is it about the weight of evidence or is it the quality of evidence? And at that point, the prosecution was simply saying, look, what we want you to do is establish that we have some evidence. And the court was trying to dig up whether there was any probative value, any additional strength in that evidence in order for them to decide whether there is evidence here that can commit the accused person to their defense or not. So basically, yes, this is an important milestone, but it is not going to influence, because the issues that were canvassed, or rather issues have already been canvassed at that level, and there's no new thing that is going to affect that ruling. So let's wait for it. Certainly, it's going to be decided on its own merit.
The victim's lawyer, rather, Wilfred Derito, had said that if the ICC Appeals Chamber ruled in favor of the prosecution today, then that would be a win for justice. Has justice lost today?
Really, justice has not lost. I think justice has won. And here is the how. Was it proper to use recanted evidence? Perhaps not, and that's what the Court of Appeal is saying. Because basically you're saying that the people or the witnesses behind this evidence are not available for cross-examination. And that is not justice to the accused persons. And so that is an important point. But the other bit also is that you do not want to find an accused person guilty for the sake of finding them guilty. And so you must give them the benefit, because they remain innocent, and their proof of guilt must be beyond any reasonable doubt. So the moment you introduce recanted evidence and you want to use that, even if you're going to come to a conclusion, certainly they will have some issue to appeal against.
We don't want to question the court, but what the prosecution and the victims' lawyers were saying was that there was some interference, what they called interference of witnesses, leading them to recant their statements. Did the appeals chamber look at this? Or how big a part does this play?
You see, there are issues here that we must separate.
Yes.
The crimes or the charges are about crimes against humanity and war crimes, if you look at it in terms of the two areas that they're being accused about. It's not about offenses against administration of justice. That can constitute a different charge if the prosecution so wishes, if they feel that they have enough evidence to subject the accused persons or any person who has interfered with the witnesses, they can charge them. But for purpose of this case, what matters is whether the material that is before the case goes on to prove the charges as laid out, not necessarily the issues as to whether there was interference or not. That is a different argument.
Kenya has been leading a charge against the use of Rule 68 and has been backed majorly by the African Union. Has the pressure by the African Union played any part in this?
There's been drama in this case, that's for sure. Political drama, unnecessary interference. I mean, obviously, some of the things we've said, whether as leadership, whether as Kenyans, against the court, has been prejudicial. Prejudicial in the sense that when a matter is before a court, when a court is seized with a matter, it is not right to actually assault that court. But this being a political process, Assembly of State Parties have found themselves talking about even the quality of evidence and the issues being canvassed in court. That certainly is a little bit unusual and unorthodox, so to speak. So, yes, there's been pressure. Yes, there's been drama. You've seen Kenyan members of parliament have gone to the court, have gone to the Hague, and have created drama there. That may, but I don't think that any court worth its salt can be persuaded or influenced by street actions and drama out there.
What next for that so-called AU versus the ICC?
I sincerely pray that we get out of this case and perhaps that the two are found not guilty or found not to have a case. And that should separate us now from the real issues. I still want us to come to our senses and say, there's nothing wrong with this court, so to speak. This court is not just a Kenyan court, or it's not just about Africans as we want to paint it. This is an international court. There's nothing wrong with it. It's been founded against some statutes, it's been founded against some rules of procedure and evidence, and is backed by the UN system. Let us respect it for what it is, since we are members of the United Nations, we are members of the AU, we are members of the international community. Let us accept that there is an international entity here that has an international jurisdiction and that must be let to play out.
But Martin, this court has spent 13 years. You spent more than 2 billion euros and prosecuted how many people? 2?
Yeah, I mean, convicted.
Convicted.
It's prosecuted many, but convicted few. Let me say this, justice is expensive. Any institution that is going to dispense justice is likely to have a long process. Look at our own institutions here. You can criticize the EACC, you can criticize the judiciary, you can say they take forever to prosecute a case or to conclude any. Justice is expensive. But we should not look at the costs to either vilify or to judge a judicial institution. Let's look at their ability and the quality of what they are doing to judge them. So this court is not about money. They are doing what they are doing. Of course, they are doing it against a very hostile environment, but that is something else.
Today's ruling, is it a game changer in the use of Rule 68, not only in this case, but in the future cases as well?
I think that before we celebrate, there are two issues here. One, there is a room for using recanted evidence, and that rule was accepted at the Assembly of State Parties. So going forward, there is room for using recanted evidence. But what's important here is that you cannot use that rule retroactively or retrospectively. So what the court has said is what would be the position at any law. That when you make a law, the law applies going forward, not going backwards. And so that's a critical statement. In others, they have just affirmed what the law should be. So that when you make a law today, it operates today going forward, not yesterday, and start looking for people and charging them what was not an offense when in that time.
Right.
Yeah.
Big blow for Fatou Bensouda. Where does the prosecution go from here?
The prosecution has many options, one of which is to say, look, we have gaps in our case. We thought we would fill up that gap with recanted evidence. Now we've been told no. They can go back to the trial chamber and say, we wish to withdraw. They can sit back and wait for the ruling in the no case to answer and be relieved to say, whoa, the court has told us, they said there's no case to answer, so let's pack up our bags and go. Right. But ideally, they still have a room to fight depending on whether the no case to answer ruling goes their way. Because the other way is to say, no, let's put the accused persons to their defense. Of course, at best, nobody wants this case to be prolonged. But in a criminal process, what works best is whenever the accused persons get their day in court, they get the opportunity to defend themselves, because then they introduce evidence that would otherwise controvert or would actually negate the evidence that the prosecution will be having. So it's a good thing in a criminal process to actually go the other way. But if it's going to waste time and if there's no reason why that should happen, then it's also a case that a case can terminate.
Finally, before I let you go very quickly, what does this mean for Ruto politically?
Politically, remember, ICC was never an issue in as to whether both the deputy president and the president were elected. Because if it was, then it would have changed the other things. If anything, actually, it might have helped. The fact that
in terms of disrupting his campaigns for 2017.
Campaigns for 2017, as long as this case is still on, he'll always have issues to worry about, travels to do, and so on. So, of course, if it was his wish, the sooner the ruling on the no case to answer comes and he's found to have no case, the better.
Right.
For now, he still has some road to cover, especially by traveling up and down.
Martin.
Thank you very much.
Great. Always great talking
Asante
to you.
sana.
Martin Oloo, just putting some perspective to today's ruling by the ICC Appeals Chair.